step, but still, end of the day, the plaintiff had suffered loss. So here again, the liability would fall on the defendant to pay compensation. This is what you call strict liability. But of course, you'll ask the question: is it fair or not? Because he has taken all the necessary steps. Why are you making him still liable, even though he has taken all the necessary steps to minimize the risk or to avoid the risk? But still, why make him liable? Something, yeah, like going back to the vicarious liability. You remember vicarious liability? The employee is at fault, am I right? In vicarious liability, the employer is at fault, am I right? Employee is at fault, am I right? But they're making the employer liable, am I right? They're making the employer liable, am I right? Yes or no? Hello, Janice?
Yes.
Why? Why are they making the employer liable? Because the employer was not negligent, but they are making the employer liable for the negligent act of the employee in vicarious liability, right? Vicarious liability is also one of the strict liability, even though the uh, employee is not liable, but only the employee is liable towards the third party, right? Cause harm or damage to third party, am I right? But they're making the employer liable. Why? You have the reason there, right, Janice? What are the reason? Why are they making the employer liable for the negligent act of the employee? Why?
I think it's because he's the employer.
Huh? Because he's the employer. Okay. Shelly, what about you, Shelly?
Sorry, can you repeat?
The question here is, you see, vicarious liability is also a strict liability,
Yeah.
Same thought like, okay, you see, in vicarious liability, the employee is the one who caused loss or damage to third party, right? The employee, am I right? In the
Yes.
course of executing his duty. In the course of executing his duty, he has caused loss or damage to a third party. But the court is making the employer liable towards the third party, right? Not the employee, am I right?
Yes.
Why? Why are they making the employer liable? Why are they making the employer liable for
Because
the negligent? Yes.
because employer is the one who recruit the employee ma, and also employer is the one who getting the benefits from the employee.
Okay.
So you need to pay.
Okay, so what we are trying to say is that the employer is the one who has recruited or hired that particular incompetent employee, am I right? So therefore, the employer has to take responsibility, one. And secondly, maybe the employer did not provide any proper training or to the employee before putting him into the job market, am I right? One. Secondly. Thirdly, the employer is the one who has given instruction for the employee to do that particular job, am I right?
Yes.
And fourthly, employer is the one who is financially sound, am I right?
Yes.
So these are the reasons they take into consideration to make the employer liable. If they were to make the employee liable, then the third party would not be getting anything, am I right? True, isn't that?
Yes.
So, okay, the same situation here, I'll give you a reason here later why they're making the defendant to pay compensation towards the plaintiff, even though the defendant had taken all the necessary steps. They have taken all the necessary steps to minimize the risk or to avoid the risk. They have taken all the necessary steps, but yet the plaintiff has suffered a loss. So they're making the defendant liable. This is what you call a strict liability. Now, to establish strict liability here, we have to run through one very, very important case called Ryland and Fletcher. If you see the slides here, you can see a case called Ryland and Fletcher. Can you all see a case there? Ryland and Fletcher? Dapat tak?
Yes. Yes.
Here, this case, whether you like it or not, you listen carefully, whether you like it or not, you need to know the facts of this case in order to answer an exam question on strict liability under the rule of Ryland and Fletcher. Okay, now, in this case, who's the plaintiff and who's the defendant? Sapper, plaintiff, and who the defendant in this case?
Ryland is the plaintiff, Fletcher is the defendant.
Okay, always this is a civil case, right? This is a civil case, right? Civil case, always the first name is the plaintiff and the second name is always the defendant. Am I right? Civil case, am I right? Okay, this is a civil case. So you all know what civil law, right? You all need to know a bit on civil law. Who need to show proof in a civil case? Who need to
Plaintiff,
show proof?
plaintiff.
The plaintiff. But in this situation, yeah, the plaintiff not necessarily need to show proof. You remember, I did earlier on the defenses for negligent, res ipsa locuta. Hello? Did you all get the thing there? Res ipsa locuta? Res R.
I think you never.
One word.
I think you never say. Never talk about.
IPSA ipsa locuta LOQUITO. You remember?
I think you never talk about negligence.
But I think I did explain about res ipsa locuta, right? Contributory negligence and all the things. You remember? Contributory negligence comes under Section 12 of the Civil Law Act 1956. You remember, I think this class I did explain, yeah. Maybe I repeat again. What do you mean by res ipsa locuta? The plaintiff, not the res ipsa locuta means it's a Latin word, it's not an English word. RES, res ipsa, IPSA, locuta, LOQUITOR, locuta. It's a Latin word, not an English word. Yeah. What do you mean by that? The plaintiff not necessary need to show proof. The plaintiff not necessary need to show proof. The circumstances of the case, is pointing the finger at the defendant. The circumstances of the case is telling the defendant is at fault. The defendant is at fault. It is not necessary the plaintiff need to show proof. The circumstances of the case itself, the situation of the case itself is pointing the finger at the defendant. You remember, I give you an example, right? Okay, how res ipsa locuta can take place, yeah? Okay, example, did I give this example? Just try to recall and see, yeah? Okay, now, the plaintiff is going for a surgery for an operation. The plaintiff is going for a surgery, okay, of course, into the operation theatre, am I right? Okay, inside the operation theatre, there'll be a doctor, a surgeon to do the surgery, and maybe a nurse to assist, am I right? Betul kan? Hello?
Yes, yes.
Yes. Okay, did I give this example in the earlier class, any one of the classes? Did I, yes or no?
Never, I think.
No.
Okay, now let me just continue and just finish off here. Okay, the doctor, the surgeon is doing the surgery. While the doctor is doing the surgery, the patient, is he conscious or unconscious at the time of doing the surgery?
Unconscious.
Of course, he'll be unconscious, right? Can you do a surgery when the patient is conscious?
Cannot.
Cannot, isn't there? Of course, he will be temporarily put to sleep by giving a jab. What's that? Anesthetic, am I right? They give him an anesthetic to put him to sleep, am I right? He wouldn't know actually what's happening to him when they're cutting his body or whatever, am I right? Okay, so this doctor has given him an anesthetic and he's put to sleep and the doctor performed the surgery. Okay, what the doctor did in that particular case, yeah, in this situation, after the surgery, he's supposed to stitch back, right? He left some bandages and some staple, the knife to do the operation, he left inside and he stitched it. And then this patient went back home. He felt very uncomfortable and severe pain inside his stomach. And then he came back to the hospital. And they did an X-ray. They found bandages and other things inside his stomach. Okay, now the question here is, this patient was unconscious. He was unconscious. He doesn't know who has put it there. But He can't even prove to say that the doctor is the one who put it there. But the circumstances of the case is pointing the finger at the doctor. Am I right? Because he was unconscious, so of course he can't show proof. But the situation itself showing the finger at the doctor. The doctor should have been negligent there because the doctor is the only person who is in control of that operation theatre. He should have left it there. No other person. Am I right? Betul kan?
Yes.
This is what we mean by reps interlocuta. The plaintiff not necessarily need to show proof. The circumstances of the case is pointing the finger at the plaintiff. Sorry, at the defendant, not the plaintiff, at the defendant. Okay, did I do the case of Donahue and Stevenson with you all? Donahue and Stevenson is a 1932 case. Did I do the case with you all? Hello? Did I do a case called Donahue versus Stevenson?
Yes, yes.
And also the case of Lim Kabi versus Abdul Latif?
I don't remember this.
It's a 1972 High Court of Kuala Lumpur case, Lim Kabi. Never, huh? Okay, that means I'll come back. You know why I never do negligence with all? Because of the midterm exam, yeah. You all have a question on Ryland and Fletcher, strict liability on Ryland and Fletcher. That's why I want to write it, do this area before going into negligence. But never mind, yeah. Okay. Now, can you all hear me? Can you all hear me? Okay, now we
Yes.
go back. Now I'll go back to the facts of the case. You know, I'll go back to the facts of the case here. What happened in Ryland and Fletcher? Very, very important here. Very, very important here. Please take down this. You need it whether for your midterm exam or even for your final year. You need this particular fact of the case here. Okay. So rightly just now you all mentioned Ryland is the plaintiff and Fletcher is the defendant in this particular case, right? Okay. In this case, the defendant is a mill owner. The defendant is a mill, M-I-L-L, mill owner. Okay, the defendant is a mill owner, mill, M-I-L. You know what's a mill, right? A factory owner, yeah? He employed some independent contractors. He engaged or he employed some independent contractors to build a reservoir in his land. To build a reservoir. You know what's a reservoir, right? Hello? Hello?
No.
Reservoir means, yeah, an artificial pond. An artificial pond, P-O-N-D. You know what's a pond? Hello? Do you all know what's a pond? P-O-N-D, pond.
Yes.
Okay, pond, huh? Okay. Not a swimming pool, yeah, not a swimming pool. A reservoir means a very big, pond, an artificial pond. Okay. So, Fletcher hired or employed some independent contractors to build a reservoir in his land. To build a reservoir in his land. So that means a big pond, a dam, a kind of a dam, but smaller than a dam, yeah, to build on his land. Okay. While the independent contractors, are you all ticking down here? Okay. While the independent contractors were digging the soil to build the reservoir. Okay. While they were digging, they found some iron shaft. Iron, I-R-O-N. Iron shaft. S. Why the noise? So, mengapa noise? Okay. While they were digging the soil, to build the reservoir, they found some iron shaft, S-H-A-F-T. That means the iron rod, pipe kind of a thing. Okay, that pipe, in his land were going through a mining area. That pipes, they found pipes, which is going to a mining area. So the so that means it's going to the plaintiff land. The plaintiff is a miner, having a mining. So that means, what I'm trying to say, So that means, the pipes were going from the plaintiff land from the defendant land into the land of the plaintiff. Pipes, going, that means deep in of the defendant land. Okay. So the contractors, while they were digging, they saw these pipes. The contractors saw these pipes, but they did not block it. Just they left it like that. They didn't block it or anything. They were negligent in not blocking it. They couldn't care less about it, Okay. So what happened? When they filled up, okay, once they completed the work, then they filled up water in this reservoir. They fill up fully water, And when they fill up that reservoir with water, the water through that shaft, gone into the neighboring land. The water from this reservoir went into the neighboring land, the plaintiff's land, and got flooded and caused lot of damage to the plaintiff land. And the plaintiff suffered lot of loss. Okay, now the question in this case is this, this case went from the lower court, upper court, and to the highest court, The issue is, now, is the owner of that, owner of the defendant land, was he aware that there was a pipe? He was not aware that there was shaft below his land, am I right? The defendant was not aware. But the contractors were aware. But they were independent contractors. Okay, when you say independent contractors, independent contractors, are they vicarious? Is the owner liable towards the independent contractor? Yes or no? Hello? This vicarious liability applies to independent contractors or what? When I did vicarious liability, can anyone help me now? Hello? Hello?
Yes.
Okay, you see here. Okay, Shelley, you are saying yes. So that means you are saying the owner of that defendant land is liable towards the independent contractors. The vicarious liability applies to independent contractors.
I guess so.
Okay, Shelley, you are saying yes, What about Janice?
Yes, because the duty of care of the owner as well.
Okay, you are saying that also. Any others? What about you, Yong Wen Bin? What about you, Yong?
I think yes also.
You think as also? Okay,
Yeah.
the answer is no. You know why? Because vicarious liability only exists when there is an employer-employee relationship. I told you all right.
Yes.
So that means, what do you mean by employer-employee relationship? Employer-employee relationship comes under Section 2 of the Employment Act 1955. Employment Act Section 2, Employment Act 1955 says that there must be an employer-employee relationship. That means, there must be a contract. So that means the employer has hired the employee to work for him on a monthly salary, right? So that means there is an employer-employee relationship. If anything goes wrong, then the employer will be liable only for contract of service and not for contract for service. Contract for service are independent contractors. They're independent contractors. There is no employer-employee relationship, So here, of course, the employer, the guy who hired the contractor will say, hey, you are only an independent contractor. Why should I held liable? That means what? That means the defendant will say, why should I be held liable? You are the independent contractor. You should take the responsibility. Am I right? Yes or no? Are you all confused now?
Yes, but how I know he is the independent contractor or the employer-employee relation?
Okay, you see, you remember when I did the vicarious liability, bear that in mind, vicarious liability, you have it in your final exam also, What do you mean by vicarious liability? Vicarious liability only applies for contract of service, because there are two types of contract. One is contract of service and the other one is contract for service. Contract of service and contract for service. We all know the difference. Okay. If there is an employer-employee relationship, if there is an employer-employee relationship, then they come under contract of service. Contract of service means they come under Section 2 of the Employment Act 1955. Section 2 of the Employment Act 1955 says there is an employer-employee relationship. Meaning, here the employer is entering into an agreement with the employee with terms and conditions normally decided by the employer. So that means the employer is hiring the employee to work for him on a monthly salary. So that means the moment you come under contract of service, the moment you come under Section 2 of the Employment Act, so that means here you're entitled for your annual leave, you're entitled for your sick leave, you're entitled for your public holidays, and also EPF deduction should be given under the EPF Act 1991, and also there must be SOCSO deduction under the SOCSO Act 1969. Am I right? You're entitled for all the, if you're unfairly or unlawfully or constructively dismissed, you have the right to go to the industrial court to seek compensation. Am I right? This only applies for contract of service because there is an employer-employee relationship. But there is no issue of vicarious liability for independent contractors. Who are independent contractors? You hire them to do a job for you. Once they've completed the job, you pay them, off they go. Taxi drivers, Grab drivers, electricians, plumbers. If you're hiring a plumber to do some work in your house for 1 week, are you his employer?
No.
No, because he's providing a service. Once he has provided the service, you pay him for his service, off you go. If you fall ill, that's his problem. Is he entitled for SOCSO deduction? Is he entitled for EPF deduction? Nothing. Because you hired him to do a specific job. Once he has completed the job, off he goes. You pay him, off he goes. This is what you call contract for service. Independent contractors, they come under contract for service. No protection under the law for them. So here, the guy, the defendant, Fletcher, hired an independent contractor to do the job. There is no employer-employee relationship. Why should the defendant pay for whatever loss suffered by the plaintiff? Am I right? Betul kan? But here, you cannot sue the independent contractor because got nothing to do with the plaintiff here. But the issue of vicarious liability doesn't apply here. But end of the day, the plaintiff has suffered a loss. If the contractor is an employee of the defendant, if the contractor is the employee of the defendant, then they can make the defendant liable automatically. Am I right? But here, he's an independent contractor. He's an independent contractor. Yeah, the job you paid him, off you gone. But the plaintiff has suffered a loss. So who should you make things liable here? But somebody has to pay compensation towards the plaintiff, right? For the loss or damage suffered by the plaintiff, right? Yes or no? So the issue of vicarious liability doesn't arise here because the defendant, the independent contractor is not an employee of the defendant here.
So teacher, what you mean is like the independent contractor need to pay the loss for the
Okay. No, here, why should the plaintiff sue the independent contractor? Because end of the day, the water came from the defendant's land into the plaintiff's land and caused damage. Am I right? True, isn't that?
Yes.
So here, this is what you need to know. What are the rules? Very, very important. This you need to know here. What are the rules? What are the rules? You need to know here what are the rules the Ryland and Fletcher has created or has established to make the defendant liable towards the plaintiff. So here, the rules in Ryland and Fletcher has made the defendant liable, Okay, how? There are few elements the court has raised in order to make the defendant liable towards the plaintiff, not the independent contractors. They never focus on the independent contractors. But in this case, they made the defendant liable towards the loss, damage suffered by the plaintiff. Okay, how? This is what we're going to look in. What are the elements the court has established? In short, we call it the rules. The rules laid down in the case of Ryland versus Fletcher. What are the rules established in this case make the defendant liable towards the plaintiff? Are you following? Hello? Okay,
Yes.
we look into all the rules there. There are 4 or 5 rules which you need to know. So that means here, the rules, the defendant should have made all this in order to make the plaintiff liable. We look into one by one now.